Hello, everyone, and welcome to Stress Free IEP, the show where we help families build their village so they can raise their neurodivergent children with confidence, clarity, and support. I'm your host, Frances Schefter, special education attorney, advocate, and fellow parent walking this journey alongside with you. Each week, we shine a light on the professional services and real world strategies that support your child both inside and outside of school. From navigating the IEP process to finding the right providers in your community, we're here to help you connect the dots and feel empowered every step of the way. Whether you're joining us live on Facebook or YouTube or listening later on your favorite podcast, we're so glad you're here. Now let's dive in and meet today's amazing guest. Manisha Patel blends legal expertise with a calm, practical approach, helping clients make sound decisions during stressful times. A collaborative family law attorney, certified mediator, and founder of a Greensboro, North Carolina firm, she guides families through separation, divorce, and co-parenting with less conflict using collaborative law and mediation. She is an elected counselor to the North Carolina State Bar and past president of the Greensboro Bar Association. Her book, End Your Marriage Peacefully, launches in 2026. Welcome to the show, Manisha.
Thank you so much for having me. I'm excited for us to have a little chat today.
Yeah, I mean, it's so people are probably like, why are you having a divorce attorney on, right? Like, how does that have anything
Right.
to do? But it is something, like, hey, we all, everybody is, I'm not going to say open to divorce. That's not the right word, but, is at risk, and I would say adding special needs children adds that
hmm
extra layer of stressful of the change for those, these children.
Yeah, absolutely. And one of the things that really kind of spoke to me about the work you do is how some of the techniques, I say the tools in our toolbox for collaborative, less adversarial separation divorce processes can also help in the education realm, trying to have maybe if they're co-parents, unmarried parents or divorced parents, trying to navigate making decisions for their children. A lot of the tools, the techniques, the options in a different setting outside of the court system can really help parents make the best choices for their children. And so I'm honored to be a guest today and kind of talk about what those tools are.
Yeah, definitely. And I know one thing that happens often that I see is like in the separation and divorce agreements, it's, both parents have equal decision making,
hmm
which I get, I understand, but there's got to be a tiebreaker, right?
Right.
Like,
Well, and a
um,
lot of that I'm sorry, I didn't mean to
no,
interrupt,
no,
but a
you're
lot
good.
of those times when, in North Carolina, family law is very state specific, at least here in North Carolina, under state law. And one of those presumptions is if it's joint legal custody, making, those monumental life decisions for children, education, medical, religion, all of those big life decisions for their children, that's one of those things. If there's no agreement, then unfortunately the law, the court will see that as you remain in the status quo, and that could be even school choice, something as what can seem as basic as school choice.
Yeah. And it's the same in Maryland. I know it's like, and
Mhm.
schools won't get involved. Schools will
Oh
not
no.
get in the middle. They're like,
Oh no.
and it's always
Yeah.
interesting. I've had cases where there's attorneys, mom has one and dad has one, or
Mhm.
advocates or something, and it's always interesting to see how how that plays out. Where I'm thinking,
Right.
like with the alternative dispute or collaborative family law, you
Yeah.
can work through all of that stuff, and it's things that people don't even think about. Like, what are you going to do if you have a special needs child with an IEP, without an IEP? How are you going to
Mhm.
address those?
Absolutely. And oftentimes, when we're in the collaborative process, let's say we use collaborative family law to resolve a divorce, property division, whatever that may be. Oftentimes, I see custody as one of the, I guess, common goals, the highest priority for parents. And oftentimes, we resolve that issue first. before the finances, before the property division. And we also always talk to our collaborative team, the parents, the attorneys, and let them know if a dispute arises in the future, we can always come back to this process and work together to figure out, what are the how are we going to meet the needs of your children? And one of those issues that's recently come up for me is a school choice, and that does come with children with special needs, and we're navigating that back through the collaborative process to help them identify which schools offer, this more specialized attention, more like smaller course or class sizes, different things like that. And so I often see that returning to the collaborative process, let's say later on, also has been helpful for families to make those decisions.
Yeah. And I know, like, I've seen it happen before that parents have very different views. Like, sometimes they're like, special education, the child needs support, they're floundering. And another parent is like, not my child. My child doesn't need all of that. And we just need to be disciplinarian.
Right.
Parenting techniques are also very different and can be in a household. And so with the collaborative divorce, like, how do you get over that when you have such difference of opinions in how to raise the children and educate your children?
So I think through collaborative divorce, I think come into the mindset of, I say you as in the parents, the you as a parent has have the decision-making ability. When it goes out of your hands, you lose that control of making decisions. It's up to a stranger, a judge. North Carolina, all family law matters are determined by a judge, not a jury, nothing like that, just a judge. And that's a stranger to your family. And oftentimes when we counsel clients about here's the wide spectrum of options that you have to resolve this dispute, collaborative family law is really attractive. Sometimes people prefer to have a parenting coordinator who can make those decisions for the children if the parents are unable to agree. Sometimes we use guardian ad litems. I'm also a trained guardian ad litem, so I have one matter right now I've been in the case for about 2 years, and we're working on with the students or the child's IEP, making sure those needs are met. And if a parent can't meet those needs, how can we find those needs met? And is that going to be a change in the school or the change in the household? If it's additional services, how are those going to be paid? And so I think there are a lot of resources for um, the different parenting styles, I will say. Um, I see in that specific instance two extremely different parenting styles. Let's say on the weekend, let's do some extra work. Let's practice some math questions that were sent home. And in one household, it might be you did your homework. Let's get on the Xbox or whatever game consoles they're playing these days.
Right. Yeah, and that's a challenge. And I can see, like, I mean, divorce, it's emotional, I'm sure,
Oh yeah.
nobody's happy about getting a divorce. Well, I shouldn't say nobody's happy, but usually not. There's
Right.
emotions there, and there's,
Oh yeah.
there's consideration. So, I love that you say that, like, letting a judge decide, because that's with any litigation. It's the
Oh
same,
yeah.
like, going to due process, in the special ed
Mhm.
world, is, you're now putting it in the hands of a judge. And so can you come to a happy medium? What can you find? And I
Right.
know for me, that's usually where I try to come in as not necessarily neutral, because obviously my clients are the
Right.
parents, but like coming in with, let's think outside of the box. Like, the school thinks this
Mm.
and we think this. Let's, what can we come up with and get creative, so that we don't have to go down, because litigation, it's hard for everyone.
Oh yeah. But I completely agree with in the family law, divorce custody world, litigation, I mean, from the start of a lawsuit, from the initial filing to being in front of a judge, for a permanent custody trial, I'll just say, at least in most big metro areas of North Carolina, at least 12 to 18 months to get in
Yeah.
front of a judge. And in that time, that's a whole school year and a summer. And what's happening with the children? How are their needs being met? And again, if the parents can't agree, it's like status quo. And so you're not only losing that time, the money, the expense of litigation, and the emotional mental drain that that litigation
Yeah.
will play, taking time off work, being stressed about maintaining your employment, making sure the kids are taken care of. If both parents are in court, what happens after school? And so it's such a myriad of like balls to keep in the air that I think, with collaborative family law, even going to mediation, having a neutral third party to come help talk to each person and realize, well, this is your best alternative to a negotiated agreement is going to be a judge, a stranger to your family telling you what to do and making those decisions for you, or a judge appointing a parenting coordinator, again, a stranger to your family making those smaller decisions that don't necessarily need a judge intervention, but a neutral who makes those decisions. And so I find that a lot of people, once they've started the collaborative process for the separation divorce process, they do find using that in the future also helps in terms of trying to make those decisions when that even the parenting styles are so different from one household to the other. Even if we're talking about diet choice, are we feeding the children complete organic, clean, um, certain foods,
Right.
no fast food at one household, you have the fast food going out to eat treats with the other household. And so that's really tough for parents. And I say for parents, that's not even scratching the surface of how difficult it is for the children.
Right, and putting it and I know I've seen before, like, well, the judge wants to hear from the child and let the child choose, and I'm like, "Ugh," to put that on a child is just awful because A, just that stress of you're making me choose between
Mhm.
mom and dad, and B, what are they using for making that decision? Well, parent A lets me play on the game box all day long and takes me to
Yeah.
fast food. Parent B makes me do my homework and makes me have a strict schedule. Who do you think they're gonna pick? Is that the best for the
Yeah.
child or not? Like,
Right,
and what is the
right,
reasoning? And I would say most kids are smart enough to tell the judge not to tell the judge those are the reasons, but
right,
like, well, because I feel this or that or the other. But to me, like mentally for that child, to put them in a position of having to choose
right.
between parents is just it
And
can't be. Yeah,
and that I will say that trauma of having to, one, go to the courthouse as a child, 2, having to speak with a stranger about your parents and your relationship with each parent, and 3, it could be an open court, it could be in an open courtroom, but no parents present, it could be what we call in chambers, which essentially is just a private conference room with a judge and the attorneys for your parents. And so, that's one of those things I really, really just refused to do in my practice when I did focus on litigation. And one thing with collaborative family law that I do love is that we have the option to engage with a variety of third party neutrals. And so, as a neutral, I would give examples as a mediator or a financial specialist, a certified family divorce uh, professional who can help break up the finances, but also a child welfare specialist. And that's someone who does speak with the children. It not so much as a guardian ad litem type role, but listens to what the child are wanting, their needs, and making some recommendations to the parents, the collaborative team, as I call it, to factor that in, and how are those needs going to be met, or the unmet needs? How do we address those through this process? And I think that's something that's so unique about collaborative family law, that it's just such a remarkable tool that can help families move forward and make those decisions.
Yeah. So I know, like, I know a little bit about collaborative divorce because one of my sweet mates,
Yeah,
she does it here in Maryland. Um, but you know, what of course I'm thinking is the parent side of like, okay, so we have attorneys, we have mediators, we have financial people, we have accountants, we have the like, who pays for all this? Like, what is that? You know, like it
yeah.
just sounds like it's getting expensive, right?
Right, right, and oftentimes okay, so each person, each parent will pay for their own attorney, and then, part of the collaborative process is you enter into what I like to call the collaborative pledge. Both parties, both parents, their attorneys, all 4 of us will sign that agreement, to say that we agree that we're entering into this process, we agree not to litigate, we agree that if everything's going to be full disclosure, all on the table. And in the event someone wants to end the collaborative process, you have to give written notice, and your collaborative attorneys are disqualified from being your
Right,
litigation attorneys. So there's that buy-in there. And then having all these third party neutrals, those are just options. Those are just resources we have, and most of the time we can figure things out. A lot of the times, I think, mediator has been really helpful to, I would call, save the collaborative process from going to litigation. And I think that really does help get that neutral person in there to give each parent that perspective, of, again, this, your best alternative is going to court, and this is what could happen. And so with the child welfare specialist, those, they're really engaged in certain situations, of, I guess, very specific instances. So special needs, it could be if there's health concerns, or behavioral issues that need to be addressed, and how are these going to be paid? And then we factor that into the, let's say, financial settlement, if that's happening in conjunction. Typically, in that collaborative pledge, you agree that you're going to split all the costs. And if one parent can't afford it at the time, there we can be creative. That's the key. We can be creative of how the other parent essentially can recoup those costs if they have to pay 100%, to make it what feels fair to the
right.
family.
And it like, I think I go back to the expensive, but, like, people don't realize how expensive litigation is, you
Oh,
know?
yeah.
And if you look at you're taking a family pot, like, yes, we have
Mhm.
2 different parents, but we're taking a family pot is what you're looking at, and if you're putting all of that into 2 attorneys to go through the litigation process is, I mean, at least 5 times more than the collaborative process.
Oh, absolutely. Before I shifted the majority of my practice to non-litigation, I had a custody case, and one child, two unmarried parents, and that case went on for, and I'll say with a disclaimer, it was both child custody and child support. That took over 2 years, and close to, I would say, $45,000. And that, I mean, that's a lot. That's some
Of
people's
your
annual
fees, and then you have the
just my
other.
fees. Yeah,
Right,
that's just one person's fees. And so that's someone's gross annual income for taxes. And so it's really hard for me to, in good conscience, even recommend going
yeah,
to court when those expenses can skyrocket. And then the judge may or may not award attorney fees to you. And that's something, we do have that mechanism under the law here in North Carolina, but it's all dependent on how the judge feels that day. Do they feel
right.
that someone can't afford it and they've acted in good faith, and the other person has acted in bad faith? how does the judge feel that day when they're making that decision? And then it's essentially being reimbursed. An attorney, you have to pay your attorney, and then those attorney fees at trial are reimbursing you for what you've paid your attorney. So you still have to pull it out of your pocket from the outset. And so it can get so expensive in the time. And I find often with collaborative family law, 6 months, even with a uh,
Yeah.
divorce issues, separation, all the property division, alimony, child custody, child support. I've had collaborative matters end after 6 to 8 weeks when
Wow.
the parents I had one situation where parents both were on the same page about custody, other than one parent had moved out for legal separation and they had temporary housing. And so that was the concern about, we need something temporary in place until that one parent has, secure long-term housing, that would maintain the school district and meet the children's needs of their activities, the tutoring, things like that. And we took a break for about 3 weeks, almost 4 weeks, came back, and they had everything resolved about property division, with the custody, the support, all of that. And, it once you get into the collaborative mindset, I think that just completely shifts a lot of people's perspective going forward, that at the end of the day, you can get this done. You can come
Yeah.
together and put those priorities of your children at the forefront, and then everything else will trickle down into place.
And I would think signing that agreement, it would lessen the and I did family law for a year and a half after law school. I was miserable. But it would lessen the, well, why is he doing that? What is she trying to get? Like
Yeah.
it's you're there to resolve together and to work together, and having that written agreement kind of like
Yeah.
doesn't it alleviates that thought of what's really going on behind this offer, behind
Mhm.
this. What are they trying to get at? And like that sneakiness that you think it might be there.
Exactly, and that's one of the things I love about collaborative family law because it takes that sneakiness out. Um, I love the fact with collaborative family law, and it's statutorily required that once you enter into the process, everything's full disclosure. And so the way I interpret that for my clients, or we talk about it in our first collaborative session as a team, and we say, and I use team as my descriptor. I don't use opposing counsel, I don't use opposing party. I use the other parent or your separated spouse, their attorney, the other attorney in our collaborative team. And I share that this is not something that you hold some piece, some screenshots, some text messages in your back pocket. Everything is out on the proverbial table or literal table from the outset. And we go through a whole process that we gather the information. We gather all the things that we may need to then brainstorm solutions and brainstorm options. And the third piece I do absolutely love about the collaborative process is the way we communicate. We use nonviolent communication. I'm not sure if you're familiar with that, but Dr. Marshall Rosenberg, I would say, is the father of nonviolent communication. And if anyone gets the chance to even listen to his audiobook, his voice is very soothing, and he plays the guitar, and it's wonderful. But not only I use it in my personal life, but I help my clients communicate in that way throughout this process. And I find that changes how they co-parent. They start using that way of communicating with their co-parent, and it takes out the animosity, the heavy feelings, and it shifts the focus back on what do we see, what are we observing, what needs are met or unmet, what feelings do those bring up, and how can we find a request to meet those needs? And so it's very formulaic, and I love, I have worksheets, essentially cheat sheets I keep out on our table during our sessions. Love having them practice when we have our one-on-one meetings. And I find that for a lot of my clients, they continue on in that method of communication, and it really just leads to a better way of co-parenting, at least the feedback I've gotten, and I use it with my family. I use it in a safe space, and I personally have seen how it improves my relationships with my family members.
Yeah, communication is it makes or breaks the relationship, right? I say that all the
Absolutely.
time. Yeah, and finding that way of communicating that everybody understands is on the same page is so helpful.
Oh, yeah.
Um, yeah, and I wanted to come back to, like you said a couple of times about, like, staying in the same school district, because
Mhm.
that's huge, and maintaining
Yeah.
status quo, because if both parents move out of that school district,
Mhm.
like, there's no legal obligation for the school district to continue.
None.
And even the in-boundary
Mhm.
school zone, I don't know how North Carolina does, but
Mhm.
in Maryland, like, you have your in-boundary school, and if nobody lives in that in-boundary school, how do you negotiate being able to stay, you know?
And I'll say it's very difficult. It's very difficult to maintain that school district once both parents have moved out or moved out of that boundary, and so that's one of those things that I even from the outset, if someone has contacted me, their spouse has moved out or I've moved out, and these are the things I need resolved. Okay, we've agreed to collaborative family law, and that's one of those things I mentioned because I know when you have to sign up for the lottery if they're trying to get into a charter school, or maintain their school district or private school has become a big issue that has been very prevalent that people are choosing a private school. Okay, well, this one parent lives 25 minutes away now from this private school, and the parent you know, who lives closer is not, let's say, the parent where the children have expressed they want to stay. And so it's one of those things where we have to figure out and balance, one, how is this going to be paid from that one pot of collective funds of that household into two households now? And if everyone is out of that school district, if it's not private school, how do we make that decision? And so that's where when someone has to move out North Carolina, you have to be physically separated, two separate domiciles, two separate addresses, and that's the biggest challenge. And if that school choice is out of, or rather, if they're both out of district or one is out of district, they have to sell a house, the marital residence. How are we going to maintain that school district? And I've had one custody matter that unfortunately was not through the collaborative process, and over the course of the past probably 4 years, around February, we come across that issue every year for the past 4 years to determine where's this child going to school? Is this child now going to school with mom and mom's new spouse and step siblings, or is the child going to go to this other new school where dad has lived, or who's going to move to be back in the same school district that's inside
Right.
those boundaries? And so it's become a challenge, and in that situation we had to go in front of a judge. It was a very lengthy trial, and unfortunately no one was happy. No one was happy with what happened, and the child had to go to a new school, and it
Ugh,
was, I think, 5th grade, 4th or 5th grade, so,
oh,
the
no.
being a little older, elementary
Yeah.
school, the cusp of, I mean, puberty, middle school age, you and I were both middle school girls at one point. We know
Yes.
that is one of the hardest times
Oh,
in a
yeah, and I
girl's
have a
life.
6th grade girl. Yep.
Yeah,
It's rough.
yeah, and so it was heartbreaking that this child had to adjust to a brand new school right before going to middle school, but,
Because mom and
um
dad couldn't make it
yeah,
work. That's
yeah,
so
and
hard.
so,
Yeah,
that is one of those situations where I would say if we can come together, if we can use a resource like a third party neutral, a mediator, or the collaborative process, let's try that. Like, it doesn't hurt to try before spending tens of thousands of dollars going through the court system.
for everybody to be miserable,
Mhm.
especially the child. And who suffers the
Exactly.
most is the child,
Yeah. Oh,
because
yeah.
lost all their friends and they have to go into a
Yeah,
new environment and they have to make new
mhm,
friends, and it's hard enough, and yeah,
yeah,
yeah, imagine. And I guess that's, like, that's one of the things people always think, litigation, divorce, due process, whatever it is, it's
mhm,
adversarial. And yes, technically, but it doesn't have to be adversarial,
right,
like,
right,
it, you guys, whether both are agreeing to the divorce or not, this is where you are, and the reality is you're
right,
getting divorced. So now, what can we do to make sure we're focusing on the child's
mhm,
needs so that they're impacted the least? You know,
right,
and I would say coming into the agreement of, like, maybe the agreement is that neither parent will ever move out of the school district, or if one does
yeah,
want to move, then the conversation is had before the move occurs, or things
yeah,
like that.
huh. Well, I will say, in the judicial district where I live and practice primarily is Guilford County, North Carolina, and, we have 100 counties in North Carolina, and each county has their own court and different local rules. Well, our county, our judicial district, actually have parenting guidelines. And these parenting guidelines, what I call, are the bare minimum go by of how to co parent. And one of those things that we have in our parenting guidelines is one, they're required to be are attached to every child custody court order. I include them in parenting agreements or parenting plans when we are not using the court process. And one of those, I guess, stipulations, one of those guidelines say if either parent anticipates a move greater than um, 20 or excuse me, 30 minutes or 30 miles from their current residence or outside of the county, then they have to provide reasonable notice. At least 30 days is how we've interpreted that. And the whole purpose is school. That's the whole crux
Yeah,
of that being included. And so that's something I talk about through the collaborative process. If I'm a mediator, I make sure people are aware of parenting guidelines. If I am in litigation, I make sure people know that from the outset because that the court holds that at such high importance that
yeah,
they're including this, and that notice provides the person to the ability either to re-enter the collaborative process, request a custody mediation, or file a motion to modify a prior custody order. And so I share that because if the law finds that at such great importance, that's something I want my client to consider, and if we're in the collaborative process, something I want the collaborative team to consider,
right.
because it could happen. You never know. Jobs may have transfers,
Yeah,
remarriage, relocation, all of that comes into
yeah,
play, and, if the courts are holding that to, a high importance, and the courts are typically, like, very low bottom bar, that needs to be also addressed and considered by the parents as
yeah, and
well.
I know in Florida, I think in Maryland too, they had, like, there's the standard clause in divorces
Mhm.
of moving, there has to be that reasonable notice, and it's usually 30 to 45 days so that the
Yeah.
parent can, and I mean, I've seen courts say, like, "Yeah, fine, parent, you can go, but now, you're going there, so this is what the visitation is gonna be
Yep.
now, and you need to pay for you to
Mhm.
fly out to visit or for the kid to fly out to you, like, that's all on you. You're choosing
Oh,
to
yeah.
move." The court's not gonna say you can't move, but
Right,
the court can
right.
say, You're not bringing your kid,
Yeah.
this is what's
And
gonna happen."
I even had a situation, it was during COVID, where a parent, a spouse, I don't wanna say the word took, it just has a negative connotation, but let's say moved to,
Mhm.
North Carolina, and one parent was, I think it was Michigan, stuck in Michigan, stuck during COVID, shut down and didn't see their child for 3 months. That was
Oh,
the start of their separation, and because they could not afford even flying, they drove. Drove
wow.
from Michigan to North Carolina for their every other weekend, and then drove back, and then once things got a little safer for flying, that parent flew to North Carolina, picked up the child, went back to Michigan, had their extended time because school was all virtual at that point, and then flew the child back, and then they flew back to
Right.
Michigan, and so
Oh,
that expense was massive, and then finally, that parent changed their job to be in the same county, the same town as their child, and still we could not get a resolution for a week on, week off
yeah.
schedule. And we waited through COVID 2.5 years to get in front of a judge to tell us, I'm a 50-50 judge. So unless you tell me there's been extreme sexual abuse, I'm going to order a week on, week off schedule. This child's in middle school. There's no reason. And we literally were like, okay, we've been
That's what we
proposing
wanted.
for a year and a half. And so it's one of those things that until some parents just have that perspective of I know what's best for my child, until a judicial authority is telling me otherwise, this is what I'm going to do. And so unfortunately in that situation, the child was harmed, lost time with their parent, had some of their special needs unmet through the school system because of the school where the child was enrolled. And that one parent who moved to North Carolina unilaterally made all those decisions. And then
Yeah.
once the out of state parent moved into town and started getting, daily access to the school, learned that IEP wasn't being followed. And I
Jeez.
need to make sure that the school and the other parent are following this IEP. And so
Right.
it was a really tough couple of years on top of going to virtual school for the child, but their needs weren't met.
Yeah.
And
And I
so,
know judges don't look good, don't look on that
oh
favorably.
no, not at all.
And
Not at all.
I've seen it that one parent moved with the child and the judge ordered the kid to be returned to the original state,
Mhm. Oh yeah.
you know? Don't care. Like y'all, you did that on your own, and no, the kid stays here, and then we can decide it.
Oh
Um,
yeah.
so it's like all of those things that people don't think about with the divorce is like, people are like, oh, whatever, we sell the house, we split assets, this, but
Yeah.
like these little things that like, well,
Mhm.
what happens if that happens, or what happens if this happens, and
Yeah.
that's where the attorneys come in and collaborative divorce
Oh yeah.
come in. And I wanted to touch on your book a little bit because I know you said it was
Yeah.
launching this year, End Your Marriage Peacefully. So who is
Yeah.
that geared towards? Like, tell me a little bit about the book.
Yeah. So I really shifted my focus into alternative dispute resolution and primarily collaborative family law about 5 to 6 years ago. And I really, as I was delving into it and wanting to make that the primary focus of my practice, I realized there are so many resources for attorneys in North Carolina and, nationally, internationally, even for attorneys to hone their skills, to have advanced skills, get more tools in their toolbox about collaborative family law. And I realized there's a lot of resources, if any, out there for people, for the regular person going through a legal separation or considering a legal separation. How are they going to know? Yes, as attorneys, we have an ethical, we have a formal ethics opinion at this point through our regulatory agency that regulates our legal profession that says you have an obligation to counsel your clients as to all of their options, litigation, collaborative family law, mediation, arbitration, all along the dispute resolution spectrum of most adversarial to least adversarial. And and I felt like we don't have those resources for people without having to go pay for an attorney, at least a consultation fee. Most family law attorneys charge consultation fees here in North Carolina. And I thought, I will provide this information for people. How can I do that? One, as you know, you have to buy a book, so somewhat
Right.
cost effective versus an attorney, $200-300 attorney for an hour. And how can I provide all those options? So through that's kind of how this book developed. And I go through this book and I talk about all of the options. And I often talk about, a little bit about my background. I come from a very service-oriented, family. I'm a first generation. My parents immigrated from India in the mid-70s, and, serving and giving back to our community was, the primary focus. It's been the guidepost in my life, and I thought, "This is a great way to do this for North Carolinians." It is N North Carolina specific in some areas, but it really it ranges for a wide audience, and one of my favorite chapters, and I will never stop talking about this, is Choose Your Own Adventure, chapter, where I use one general, scenario, and we walk through each of those different aspects along that spectrum of dispute resolution. And it really helps people understand on a basic level without too much legal jargon to figure out what's going to be best for my situation, for my family. Is it just a custody dispute? Do we have to divvy up the finances, the property, the assets? We just have debt. How are we going to divide the debt? Different things like that. Another chapter I really love is the dependence chapter, is about children, but also pets. I see a lot of people who bring up their pets in these
Oh, yeah.
collaborative situations, and the law doesn't allow anything for pets other than we see it the same thing as your living room sofa. It's just a piece of
Yep.
personal property, and so
Yep.
it also talks about different ways you can factor in your pets, their family. I love my dog. I have his picture in my office on my desk right now. And so it's one of those things where it puts the control back in your hands, and I go through and talk about the different options, about what the law is. I include a glossary for those legal terms, and then resources. I think the resources are really helpful for people to get the information and feel empowered to make the right choice for their
Yeah.
family, because we're
Informed.
not
Yeah.
breaking we're not breaking up a family, we're just restructuring how that family looks.
I like that. Yeah, I like that. That is so awesome. So I love it. I know we'll put the link once you have the link to buy it, we'll put the
Yes.
link down in the show
Yeah.
notes. But that sounds great. Like, yeah, listening to you with, talking about family law in North Carolina, my knowledge of in DC and Maryland and Florida, they're all very similar
Yeah.
in what process is. So I would say it's probably a book that would be relevant for almost everyone.
Oh, yeah.
Um, that
Absolutely.
that would be so helpful to just like, because nobody wants adversarial,
Yeah.
if we could do it peacefully. That
Right.
sounds great. Yeah,
Yeah.
so thank you so much for being on the show and sharing all of your words of
Of
wisdom with our
course.
listeners.
Thank you so much for having me. It's been lovely.
Thank you. And thank you all for joining us on this episode of Stress Free IEP. We hope today's conversation gave you new tools, insights, or just a little more peace of mind as you support your neurodivergent child. Next week, we will have episode 139, where Matthew Fischletter on finding your parenting voice during IEP stress. Don't forget to subscribe so you never miss an episode. And if you found this episode helpful, please share it with someone in your village. You can always learn more and connect with me at schefterlaw.com or follow along on social media. Until next time, remember, you do not have to do it all alone.